Mr David Shoebridge.
Mr President, I move, according to contingent notice, that standing and sessional orders be suspended to allow a motion to be moved forthwith that private members' business item number 283, outside the order of precedence, relating to Roman Catholic Church Trust Property Amendment (Justice for Victims) bill be called on forthwith.
The question is that the motion be agreed to. All those of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it.
Mr President, I move that private members' business item number 283, outside the order of precedence, be called on forthwith.
The question is that the motion be agreed to. All those of that opinion say aye. To the contrary, no. I think the ayes have it. The ayes have it.
Mr President, I move, according to notice, that leave be given to bring in a bill for an act to amend the Roman Catholic Church Trust Property Act of 1936 to provide for the ability of victims of sexual abuse where the abuser is found to be a member of the Catholic clergy and or another official and or officer in the Church to satisfy judgments awarded against such abusers as a judgment debt payable from the assets of the Trust and for other related purposes.
The question is that leave be given to bring in a bill. All those of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it.
Mr President, I present the bill and move that this bill be now read a first time and printed.
The question is that the bill be now read a first time and printed. All those of that opinion say aye.
Aye.
To the contrary, no. I think the ayes have it. The ayes have it.
Roman Catholic Church Trust Property Amendment, Justice for Victims Bill 2014, first reading.
Mr David Shoebridge.
Mr President, I move that this bill be now read a second time.
Point of order.
The Honourable Dr Peter Phelps on a point of order.
In relation to the title of the bill, does the title of the bill retain an argument in relation to the use of the words justice for victims, and as such, does it need to be amended by the House?
Against justice.
David, we can amend. We can consider this. It's off. Yeah. There's no point of order.
Thank you, Mr President. Can I note at the outset that we have in the President's Gallery both Anthony and Chrissy Foster, who are campaigners in this area and themselves have a long personal history with the failings of this aspect of the law and indeed the failings of the Church in relation to their daughters. And I also pay my respect to those campaigners in the gallery, survivors of abuse and campaigners for justice in this area of the law. Mr President, a core principle of any modern responsible democracy is that no individual or organisation is to be beyond the law. Tragically, this principle does not apply when victims of sexual abuse by Catholic clergy or other officials of that church pursue civil claims. And this means that victims of abuse by members of the Catholic clergy are barred from an important means of obtaining justice, and the organisation responsible for their pain and suffering and their losses escapes accountability. Given the historical failure of the Church to address claims of abuse and the mounting evidence of mismanagement within the organisation, it is essential for lawmakers to close legal loopholes which enable the Church to escape accountability on technicalities. In consultation with victims and survivors, support groups, lawyers and other stakeholders, the Greens have drafted the Justice for Victims Bill, which will allow victims to sue the Church's property trusts. This will mean that civil claims by victims of sexual abuse against the Church will be decided on their merits not on a legal technicality. The provisions of the Roman Catholic Church Trust Property Act date back to 1936 and are such that victims of abuse are barred from an important means of obtaining justice. This is done by placing the Church's assets in statutory trusts, which are effectively immune from claims by victims of abuse. This has particular importance for the Catholic Church, which, as an unincorporated association, is not a legal entity and cannot be sued in its own name. With the perpetrators, often priests, having no assets, the Church unable to be sued, and the Trust's assets protected from claims, the end result is that many victims have no recourse to justice. This is a matter of justice that extends beyond those who are abused or who are the family or friends of those who suffered abuse. There are people of goodwill within the Church, as well as growing support base outside the Church, who are demanding change. I urge all members to closely review and then support this legislation, which will force the Church out of the shadows, where it can face real justice and genuine accountability. I turn now to a brief discussion of the case that has highlighted these concerns. It's called the case of Ellis. In a 2007 decision of the New South Wales Court of Appeal, which was affirmed on appeal to the High Court, John Ellis was denied compensation for sexual abuse he suffered at the hands of an assistant priest at Bass Hill Parish between 1974 and 1979. Mr Ellis could not sue the deceased's assistant priest. Neither could he sue the Church. Mr Ellis therefore sued the current Church leadership in the form of Cardinal Pell and the property trust that at all times had held the Church's assets. And I pause here to note that Mr Ellis is in the gallery today. In court, the Church did not base their defence on denying Mr Ellis had been abused. We now know that the Church was in possession of overwhelming evidence supporting Mr Ellis's claims. Instead, they persuaded the court that the present leaders of the Catholic Church could not be held responsible for breaches of care by former members of the unincorporated association that is otherwise known as the Catholic Church. The Church also argued, and the court agreed, that the property trust could not be sued by victims of abuse, as the trust was solely responsible for property matters and therefore not liable for any sexual abuse by members or officials of the Church. Had Mr Ellis been injured by a falling rafter in a church hall, then the trust would have been responsible. But because his injury was caused by a sexual assault from an assistant priest, the trust was said not to be responsible. The result was that Mr Ellis's case was dismissed. Not only that, he was ordered to pay the cardinals and the trust's legal costs. Mr Ellis was left with no legal remedy. Victims and the Church now simply refer to this case as the Ellis defence. I turn now to the more specific provisions of the bill. The Justice for Victims Bill aims to do a very simple thing. It proposes to allow victims of sexual abuse to sue the property trusts as though they were the Church. It aims to force the Church to defend these sexual abuse claims on their merits, not on legal technicalities. And in doing so, the bill attempts to level the playing field and give those victims a real and viable legal remedy. The long title of the bill describes its intentions and functions. It reads, "An Act to amend the Roman Catholic Church Trust Property Act 1936 to provide for the ability of victims of sexual abuse, where the abuser is found to be a member of the Catholic clergy and or another official and or officer in the Church, to satisfy judgments awarded against such abusers as a judgment debt payable from the assets of the trust and for other related purposes." The bill, as I said before, amends a long-standing act made by this Parliament, the Roman Catholic Church Trust Property Act 1936, to insert a new Part 3 into the Act regarding sexual abuse claims to be paid from trust funds. Section 18 of the Act, of this bill, provides that the plaintiff in civil proceedings relating to sexual abuse or negligence by a member of the Church's clergy, a church official or a church teacher in relation to a person who was at the time of the sexual abuse or failure to exercise reasonable care and skill under the care of the Church may join as a defendant to these proceedings. A, the body corporate established under this Act for the diocese in which the abuse or failure or the majority of the abuse or failure is alleged to have occurred. And B, the bishop and the diocesan consultors of the diocese in which the abuse or failure, or the majority of the abuse or failure, is alleged to have occurred in their capacity as trustees of church trust property in that diocese. In other words, both the trust and the trustees may be joined to the proceedings in those circumstances. And subsection 2 provides for liability as follows. In respect of any such proceedings, the relevant body corporate and its trustees are jointly and severally liable as if they were the member of the church's clergy, the church official, or the church teacher against whom the proceedings were also brought. In other words, the corporate entity that holds the trust and the trustees stand in the shoes of the member of the clergy, of the church official, and indeed of the church. And they have available to them each and every defence, each and every legal remedy that those other defendants would have. But they also carry with that a genuine liability that if a breach of duty of care is proven, if a claim is made out that abuse occurred and there was a breach of duty by these persons who are members of or closely associated with the church, well then the trust is liable, and it's the trust that holds the funds. It's the trust that is the only defendant that is not a straw man in these proceedings. Section 17 of the bill provides the following definitions. It defines a church official to mean any person who acts as a representative of the church and includes an official, officer or member of staff of the church or of a diocese, a lay assistant for the church or for a diocese in the church, and a volunteer for the church or for a diocese in the church. There is a definition of church teacher, and there's a definition of member of the church's clergy, which includes archbishops, bishops, priests, sisters, nuns, brothers, monks, and other members of religious orders of the church. And sexual abuse is defined to mean sexual conduct or conduct that includes sexual conduct, whether or not there was apparent consent to that conduct, and whether or not that conduct would at the time of the relevant conduct constitute a sexual offence, perpetrated by a person who was at the time of the relevant conduct a member of the church's clergy, a church official, or a church teacher while acting in his or her capacity as a member or official. And to overcome a serious lack in the law as to fiduciary duty in this jurisdiction, a lack, I might say, which has been overcome in other jurisdictions such as the United Kingdom and the United States. Subsection 2 of Section 17 provides, for the purposes of this part, a person was under the care of the church if the person was owed a duty of care or fiduciary duty by the church, a member of the church's clergy, a church official or a church teacher, and includes, but is not limited to, having owed such a duty in the capacities as a member or parishioner of the church, a nun, a monk or seminarian of the church, and other categories. The bill also provides that where the plaintiff intends to make use of this provision, they must give notice of that within 28 days of the filing of any statement of claim. The proposed new Section 19 provides that where a person is owed money as a result of a judgment based on a finding in relation to abuse by a member of the clergy, church official or church teacher, that they can seek to recover that debt from the Roman Catholic Church Property Trust or the bishop, the diocesan consultors or the body corporate established under the Roman Catholic Church Communities Lands Act 1942. Importantly, the bill also provides for a suspension of the operation of the Limitation Act 1969 for a period of 2 years from the date of the commencement of this bill. Increasingly, we are seeing in jurisdictions around the planet, common law jurisdictions in particular, such as British Columbia in Canada, an array of state jurisdictions in the United States, a move to entirely remove or suspend the statute of limitations for historic child sexual abuse claims. And the purpose of the 2-year suspension proposed in this bill is to allow victims of clergy abuse who might have not brought their claim due to the existence of the Ellis defence, but whose claim is otherwise statute barred, an opportunity to seek fair compensation without having to seek leave. We know that the average delay for victims of childhood sexual abuse to bring a claim is greater than 20 years. The standard statute of limitations for these claims is just 3 years from the time the victim turns 18. The practical result of this is that the great majority of claims are statute barred, and therefore the victim, the survivor of abuse, must obtain the court's leave to proceed out of time. This leave to proceed is a serious hurdle for many victims to overcome. It places an unfair bargaining power in the hands of the Church from the very commencement of the claim or proceedings. This bill, as a starting point, proposes a 2-year suspension of the statute of limitations for historic child sexual abuse claims, where the victim was under the care of the Church. This is a modest but real step forward to level the playing field in this fraught area of litigation. And indeed, it should be the start of a conversation and a direct move in this Parliament to entirely remove the statute of limitations for historic child sexual abuse claims. Recently, we have seen the Church seeking to justify its actions in relation to the matter of Ellis, to defend its actions, to explain its actions. And we know that from the time that John Ellis entered into and then left the Towards Healing process that had been established by the Church, and for the entire course of his subsequent civil claim, George Pell was the Archbishop of the Sydney Diocese. In recent days, we have heard the Archbishop, now Cardinal, give evidence before the Royal Commission into institutional responses to child sexual abuse. Cardinal Pell was questioned about his involvement in the Ellis case, and in particular, the aggressive court response that created the Ellis defence precedent in the courts of this state. Cardinal Pell acknowledges that he was the Archbishop at the time that Mr Ellis's complaint was received by the Church, and he further advises that he had a large number of discussions about the case at the time. But he has maintained that he was guided by his advisers, his lawyers and the Church officials, rather than being the key decision maker himself. Regarding the treatment of Mr Ellis in both that internal process and in the proceedings, a number of officials who previously appeared at the Commission advised that Cardinal Pell knew about Mr Ellis's compensation request, including his offer to resolve the matter for the very modest sum of $100,000. The Cardinal claimed that he thought the figure was $750,000, and that was too high, and there was no point in negotiating, and he refused mediation. It is worth remarking that the Church spent well in excess of $1 million in legal defence of this matter, and the case finished costing the Archdiocese approximately $1.5 million, including a significant ex gratia payment to Mr Ellis. It was rightly suggested by counsel assisting the Commission, Gail Furness, that it was inconceivable that the Cardinal was not aware of the details of Mr Ellis's claim, and to this he responded, "It's not a question of what's conceivable or logically possible. The fact is that I wasn't informed about any of this." But the Cardinal does admit that he endorsed the decision not to enter mediation at the start of proceedings, claiming that he did not recognise the woundedness of Mr Ellis. Despite his evidence to the Commission, in his statement to the Commission of just 24th of February this year, the Cardinal admitted that he explicitly endorsed the major strategies of the defence, being the aggressive defence of the civil claim from John Ellis. He testified that this defence was intended to serve as a warning to other plaintiffs who might be considering action against the Church that, in the words of the Cardinal, they should think clearly. The Cardinal's private secretary, Dr Michael Casey, last week told the Royal Commission that the Cardinal had directly ordered the legal team to pursue an aggressive cross-examination, including bringing into question whether Mr Ellis had in fact been abused, despite the fact that they had such overwhelming evidence, and despite the fact of abuse had been accepted even in the Church's own Towards Healing process. While Cardinal Pell admits in retrospect that the litigation went too far, he also distances himself from any responsibility for this occurrence. Given his position at the time of the litigation, that is remarkable. He also stands by the approach in the case that saw Mr Ellis's case fail on the legal technicality of the Ellis defence, saying, "Mr Ellis sued improper parties who defended inappropriate proceedings against them." His statement renders these callous and damaging tactics taken against a victim of horrific abuse as follows. I would now say, looking back, that these legal measures, though effective, were disproportionate to the objective and to the psychological state of Mr Ellis, as I now better understand it. Prior to this week's hearings in the Royal Commission, Church and Cardinal Pell have robustly defended the use of this legal strategy that is widely known as the Ellis defence, to the point where they have attempted to deny the obvious truth. In a statement published on the Catholic Archdiocese of Sydney's website, they have previously said, and I quote, "There is no such thing as the Ellis defence. The Ellis decision did not create new law. It did not create a shield to protect church parties from legal action. Church parties can and have been sued. After Mr Ellis lost his case, he received several $100,000 in financial assistance from the Archdiocese. In addition, the body corporate of the Archdiocese did not require Mr Ellis to pay its costs of the case, even though the court had ordered Mr Ellis to do so. The suggestion that the Church cannot be sued by victims of sexual abuse is incorrect. It further says that church officials and church entities responsible for abuse in the church, either directly or by their negligence, can be and are sued. Ellis stands for nothing more, so the Cardinal says, than the common sense proposition that you cannot be liable for wrongdoing of others unless you are directly or indirectly responsible for the supervising of their conduct. This statement by the Church wraps a large lie around a small and irrelevant truth. Yes, it is true that the case of Ellis does not say you cannot bring proceedings against the trustees, the trust, or the current bishop for the abuse suffered in the past. That much is true. But what the Church omits to say is this, that the case of Ellis loudly and unambiguously states that if a victim does bring such a claim, then they will inevitably lose, as none of these entities are liable at law. The use of the Ellis defence has been an extremely successful legal strategy for the Church. Recent evidence given in the Commission has shown that it's estimated that the Sydney Archdiocese alone has more than $1 billion in assets. Since 2001, we now know that in the time of the management of Cardinal Pell, that the Archdiocese has paid out only $8 million to some 82 separate victims' claims. To seek to obtain some perspective on the wealth of the Church, reference can be had to a 2005 Business Review Weekly analysis that said if the Catholic Church were a corporation, it would be one of the top 5 in the country. And according to Business Review Weekly in 2005, the Catholic Church in Australia was not only the biggest religious group in the country in terms of financial terms, but also the richest non-profit organisation, with an annual turnover in 2005 of some $16.2 billion. I make reference to this report from the Business Review Weekly because the Church has no obligation to provide its accounts for scrutiny to anyone. It never has, and it never will, unless it's been ordered to do so, such as we've seen in recent days in the Commission. Mr President, as the Australian Lawyers Alliance said in a statement just yesterday, and I read, "The most serious concern is that the Church remains wedded to protecting its treasure ahead of children in its care. The Church gives its clergy great authority over their victims, appointed and dismissed them, and determined how they carried out their duties. When asked by Justice McClelland why the Church should not be liable for the consequences, Cardinal Pell simply asserted his duty to protect the Church's assets. It is now clear that the apparent concessions emanating from Cardinal Pell, from Francis Sullivan of Truth Healing and Reconciliation, are simply empty gestures, not intending to help past victims, and which would help very few future victims. Legislation to deal with unjust limitation periods and make the trustees of the Church able to be sued, making them responsible for the priests that the Church appoints, should now be recommended and pursued in all Australian states and territories. Cardinal Pell said it would be unfair to treat the Catholic Church different from other organisations. The Australian Lawyers Alliance agrees. The Catholic Church is the only major organisation in Australia claiming immunity from suit and no responsibility for its clergy. It's time to end the legal abuse of victims superimposed upon sexual abuse by clergy." Mr President, I could not agree more. It is for this reason that I am moving this bill today and looking for the support of this Parliament. And I note that this bill did not just appear as a result of this last week's hearing. It has been a product of years of consultation, years of careful consideration. It has broad support amongst survivors and victims and those advocates demanding some form of balance and justice. We can't simply wait years for the Royal Commission to finally report. At best, we're likely to see recommendations fixing the matter prospectively by moves to incorporate the Church. We'll put in place a procedure for the dealing of claims in the future. But the thousands of victims who have approached the Royal Commission, the thousands of victims of past sexual abuse and historical abuse, require their elected representatives to take this strong step, establish a level playing field and establish justice for victims, not just in New South Wales, but in states and territories across this country. I commend the bill to the House.
Hear, hear.
Mr. President,